Hey, what's up, guys? Legal Bro here. Today we are giving you an update on the Camp Lejeune litigation. Let's get into it. And as you know, at the end of July 2022, the Camp Lejeune Justice Act allowed military families, civilians, anybody that was drinking contaminated water, including those in utero, at Camp Lejeune between 1953 and 1987 for a combined period of 30 days or greater, and has some injury or debilitating illness may file a claim under this new law. So the first claims or batch of claims at the administrative level, remember folks, you have to file a claim with the Navy, right, before you can ever file a lawsuit. So the first claims were filed in August of 2022, which means the first lawsuits couldn't be filed until around February 10th, 2023. Now, at that time period, what we found was back in February, we have thousands and thousands and thousands of lawsuits being filed, and it sort of kicked off this litigation and has led us to where we are right now. Now, the Judge Devers in the Eastern District of North Carolina, and remember, the Eastern District of North Carolina is the exclusive jurisdiction for Camp Lejeune claim. So ordinarily, if you filed a claim in a mass tort like a 3M, you'd file it in your state, it would get consolidated for the pre-suit, and then when it would go to trial, it would go back to your home district, right? Wherever you reside, whatever state that is. Well, Camp Lejeune claims are a little bit different. Once the 6-month period where the government either accepts liability, denies liability, or does nothing, then you file your case with the Eastern District of North Carolina. Very interesting. Judge Devers has come out and said that if each district within the Eastern District of North Carolina, there are 4, if they tried each case individually, it would take 1,900 years through trial, and I'm sure up to the Court of Appeal in the 4th Circuit. So what are they doing, right? What does the judge want to do? Well, they're going to do a couple of things. The first is they have a motion in front of them to consolidate all of these cases, right? Make them one, make them streamlined. Here we go, court. Here's what we've got. We've got these attorneys who are going to kind of lead the way. We've got these attorneys that are going to be on the committees, and we want to do X, Y, and Z moving forward, right? We want to use these specific experts, right? We don't need an expert per claim. We want one, bladder expert, one pancreas expert, throat expert, whatever it is, right? And the court's going to say, okay, yeah, we think that's okay, or no, we need to have everybody individually examined by these experts, or we need each case kind of individual. The good news for Camp Lejeune victims is that the government has already recognized a presumptive service connection. So if you were at Camp Lejeune and you have bladder cancer, that would be presumptively connected, right? And there are many others, and you can look at some of my other videos where we talk about that. But the interesting thing is that the judge in this Camp Lejeune case, Devers, has come out and said, look, we aren't going to be around here like the Roman Empire for the next 1,900 years, folks. We need to get these cases settled, and we need to get the victims compensated. But as you know, because it's the government, they've got more moving parts, right? They've got certain resources. There's a issue with the debt ceiling that could go into the budget for some of these claims. There are a lot of moving parts, but the judge is basically saying, look, we got to come up with some sort of resolution here so that these victims get compensated. We're not kicking the can down the road till kingdom come. Very, very interesting. I may do a video at some point on the types of settlement value, right? If you have different claims based on other mass torts, right? So if you had like a non-Hodgkin's lymphoma case in, say, Roundup, right? Mass tort for Roundup. What was that worth? And can you compare that to what the value would be for a Camp Lejeune case? But, if anybody's interested, let me know below. What do you want me to comment on or talk about the process? But there are a few amendments floating around Congress that are trying to limit or cap the amount an attorney can charge to assist with a Camp Lejeune justice claim. And obviously all of the marketing companies out there that are spreading how Camp Lejeune's a class action and all this other baloney and nonsense, they're not helping us, right? They're actually making it much worse because they're not telling the truth. Camp Lejeune isn't a class action. You can't have a class action unless everybody's injuries are common. So bladder cancer and stomach cancer are not going to fit under a class action. It would be almost impossible to have a class action unless you could find a class representative for all of these different areas. If you have any other questions or you want any other information about a Camp Lejeune claim, like and subscribe to follow Camp Lejeune Justice Act and the claims journey. It's going to be interesting. Right now, it's grinded to a halt. They have not paid out any claims that I'm aware of. They have not settled any cases that have been filed that I'm aware of, but we're going to keep you informed. As always, Legal Bro, here to protect our veterans and military families.